So this is chapter 5, working of institutions, democratic politics, class 9th. So we are going to study this chapter. In this chapter we are going to study about various institutions, legislature, executive and judiciary, and how these institutions function, and how they are connected. All these things we will be discussing. So in the beginning of the chapter, a government order is there, office memorandum signed by a joint secretary, and this relates to 27% reservation being given to ACBC, socially and educationally backward classes. So we will keep in mind this memorandum, because at times we will be referring to this also. Then the thing is that who are the decision makers? So obviously the officer who signed this office memorandum would not have been the decision maker, because this was a very big decision making, and we will see how various institutions were involved in this. So in fact this office memorandum was the culmination of a long chain of events. There was one second backward classes commission established in 1979, BP Mandal commission it was, and the report was submitted, and it recommended 27% reservation in 1980 itself. But the report and recommendations were discussed in the parliament. Okay, the role of parliament comes, but it decision was not taken. Finally in 1989 one government, Janata Party government, they gave in the manifesto that we will be implementing this 27% reservation, and then they implemented this. Now see, after the VP Singh government came, the decision was taken because they gave it in their manifesto. So the President of India in his address to the Parliament announced that there is a government policy that they are going to implement the recommendations of the Mandal Commission. So the involvement of President is there in that decision making office memorandum that we discussed. Then the Union Cabinet took a formal decision, okay, that we are going to implement recommendations. Then the Prime Minister gave a statement in the Houses of the Parliament that yes, we are going to implement these recommendations. Then the decision of Cabinet was sent to the DOPT, Department of Personnel and Training, and then the senior officers, in fact the Joint Secretary, then by his signature, that order was released. So this is how we can see how the Parliament, then the President, and then the Cabinet and Prime Minister, and then that officer, such long chain of people are involved in that decision making. But after that this was highly debated, and in fact the matter went to even Supreme Court also, okay, because there was so much differences that this reservation will lead to some both arguments and counter arguments were running, that some felt that it was needed so that the inequalities on the basis of different caste is not there, a fair opportunity to represent in the government for those communities, SEBC category people who will be there. So some arguments in favor was there, but there was also counter arguments that it will go against the equality of opportunity for those who don't belong to backward communities. They will be denied jobs even if they are more qualified. All those things, arguments and counter arguments were there, and that then the matter went to Supreme Court also. And then the Supreme Court decided this reservation criteria difficulty, the issue in Indira Sahni case, and in that there was the 50% cap was given on the reservation, and also the concept of creamy layer was brought, that well-to-do persons among backward classes will be excluded from the benefit of reservation. That's why we can see how many people are involved in that decision making, including the Supreme Court. Okay, now let us see the need of political institution. So the need of political institution is that the government has to is responsible for ensuring security to citizens and providing facilities of education, health, welfare mechanisms are there, to be there, welfare schemes are there. So some persons have to take decision that how these activities are to be run. Then some have to implement those decisions, and after that if dispute arises regarding the decisions that have been taken or implementation of those decisions, then the role of judiciary may also come. So all these things are there, meaning that one is that one has there must be some institution to decide, to take decisions, then the other institution to implement the decisions, then the third institution to adjudicate the disputes if any dispute is arising on the decisions or in the course of their implementation. That's why arrangements are needed, several arrangements are needed, and these arrangements are called institutions. Okay friends, this is how That's why there is prime minister and cabinet who taking important policy decisions, then the civil servants working together and responsible for implementation of the minister's decision, and then the Supreme Court, of course, to adjudicate the disputes. There are other institutions also, such as CAG is there, CEC is there, ECI, Election Commission of India is there. So other institutions have their roles also. So this is how various institutions are required. But the thing is that when there are so many institutions, then there will be meetings, committees, routine works are there, and so many institutions are involved in decision making. This leads to delay in decision making. That's why one might feel that it would be better if one person is taking all the decision, but then it will be against the spirit of democracy. One person cannot take all the decisions. Also, one important point is that institutions make it difficult to have a good decision. It makes it difficult to have a good decision, but the thing is that at the same time they makes it difficult to rush through a bad decision also. So if they are a hindrance in the good decision, then at least they are a hindrance in bad decision also. That's why democratic governments always insist on institutions. This is why political institutions are needed. Now we will be studying about parliament and political executive, a bit about judiciary also, and see all these things that we are going to discuss have been given in the Constitution of India very explicitly. Okay, so now let us see the parliament. If we recall the office memorandum, we will remember that in that case parliament was also involved in the decision making process, because prime minister went to the parliament and made the statement. Similarly, the president mentioned in his address to the parliament that the recommendations are to be implemented. This is the policy of the government. Then the report of the Mandal Commission was also discussed. So the role of parliament is also there in that decision making process. Okay, and now if parliament was not in favor of this decision, then the parliament would have brought the no confidence motion and the government would have to go. So we can say that the parliament, the approval of the parliament was also there indirectly, though the decision was taken on the executive basis, but that was also indirectly approved by the parliament. Otherwise no confidence motion and the whole council of ministers would have to go. Now the question is why we need a parliament. So the parliament is in fact the supreme political authority on behalf of the people. It is said to be embodiment of the people's will. It represents the people's will. It exercises the political authority on behalf of the people in many ways. Now let us see the role of the parliament. So parliament is the final authority for making laws. So enactment of laws is the first and foremost work of function of the parliament. They can change existing laws, they can abolish existing laws, they can make new laws also. So these are the things. Then the parliaments yes. In some countries like India, this control is direct and full. Who run the government and can take decisions only so long as they enjoy support of the parliament. So the parliament also exercises some control over those who run the government, because the government can be there. For example, we take India, the government will remain in power only till they are enjoying support of the parliament, particularly Lok Sabha. So this is how parliament is taking having a control over those who run the government. Then the parliament also controls the money that the government have to will have to expend, and this is how there is a budget session also, and budget is passed. That's why the public money can be spent only when the parliament sanctions it. So it is controlling the economic part also of the government. Then the parliament is the highest forum of discussion, debate on public issues and various national policies, and in fact parliament can seek any information about any matter. And in fact parliament is the authentic source for any information about the government of India or any government. So this is how the role of parliament. There are 4 important roles. The 4th one is also very important. This is forum of discussion and debate on various public issues. Now 2 houses of parliament are there. So we know that upper chamber and lower chamber. The upper chamber is called Rajya Sabha, it is indirectly elected, and the lower chamber is Lok Sabha, directly elected. But upper and lower chamber does not mean that Rajya Sabha is more powerful or less powerful. It is not about being powerful or not. One thing I forgot to tell you, President of India is also a part of parliament. So the parliament of India constitutes of Lok Sabha, Rajya Sabha, and then also the President of India. In fact, article perhaps 69 says that President of India is also a part of the parliament. Okay. And that's why all laws made in the houses are brought before the president for the assent of the president. Unless the president signs that act, that bill, it does not become an act. So president is also a part of the parliament. You must keep it in mind. Now let us see the role of these houses. So any ordinary law needs to be passed by both the houses, ordinary law, okay, and the final decision, but if there is some deadlock or some sort of conditions are there, then joint session can also be brought. But in case of joint session, because of numerical strength, Lok Sabha is likely to prevail. This is how many times we say that Lok Sabha is more powerful than Rajya Sabha, but we should not say like that anyways. As an institution and entity, we should not say like this anyways. Lok Sabha exercises more powers in case of money matters, okay. Under article 110 we have money bills. The budget is also a type of money bill. So when Lok Sabha passes all these things, then Rajya Sabha cannot reject money bills, or Rajya Sabha can at most delay it by 14 days or suggest changes in it. But again, if Rajya Sabha is suggesting changes, the Lok Sabha may accept or may not accept. That means it is not binding on the Lok Sabha how it is going to take action on that. The most important aspect is that Lok Sabha controls the Council of Ministers. That Lok Sabha, the Council of Ministers comes from the Lok Sabha, and a person enjoying the support of majority in the Lok Sabha will remain, will be there as will remain as Prime Minister. Okay. If the majority of the Lok Sabha members say they have no confidence in the Council of Ministers, then the Council of Ministers will have to resign, and the Prime Minister will also have to quit. So Rajya Sabha has no power in this aspect. That's why many types of motions can be brought in Lok Sabha only, not in Rajya Sabha. Because Lok Sabha is the house which gives the Council of Ministers, and Lok Sabha is the house which, if passes the no confidence motion, then the Council of Ministers will have to go. This is how the Parliament. Then the political executive we have to discuss. In fact, we can see that Prime Minister is taking the decision in that office memorandum, and the cabinet is also there. But we also know that he could not have taken the decision if he did not have the support from the Lok Sabha. Otherwise, no confidence motion would have come, and then the Prime Minister would have to go. So in that sense, he was only executing the wishes of the Parliament. In fact, when we speak about executive means execution of the policies of the government. Okay, they take day-to-day decisions, but do not exercise supreme power on behalf of the people. In fact, the supreme power on behalf of the people is enjoyed by Parliament. Okay, so this is how it is. Now there are two types of executive: political and permanent executive. Permanent executive are the civil servants, bureaucracy. They remain in service for 30 years or more than that. They are permanent. Parties come into power and they go, but they remain permanent executive part. And the political part, it constitutes the power, the political party who is in power and ruling, and constitutes the Council of Ministers. Okay, so this is how you have to see the long term basis. This is in case of permanent executive, and persons working in civil services are called civil servants. They are the permanent side of the executive. But see, one is very important. Why does the political executive have more power than the non-political executive? That is, ministers are more powerful than the civil servants. Although there is one debate that the civil servants are more educated and have expert knowledge. But why they are more powerful? They are less powerful than the ministers who are supposed to be laymen. The advisors working in the finance ministry know more about economics than the finance ministry. This is how one example is being given. The reason is very simple, that the minister is elected by the people and they have to face the elections. That's why they are empowered to exercise the will of the people on their behalf. That means they are elected by the people, they are representing the people, and they are responsible to the people when they will again go for election, during the election time, to the people, that yes, what I have done or not done. That is, the minister is finally answerable to the people, and the civil servants are acting behind the curtain. They don't come forward towards the people. For any action, for anything, for any policy, the government and the ministers are held responsible and not the civil servants. That's why the ministers should take the final decision. In fact, they are expected to take help of expert in the matters of our ministry, and in fact, expert opinion are taken, but the final decision is taken by those ministers. Now let us see Prime Minister and Council of Ministers. So Prime Minister is the most important political institution because he is the head of the government, not head of the state. Head of the state is President. But there is no direct election to the post of Prime Minister. No direct election for Prime Minister. Okay. Then the President appoints the Prime Minister. This is how we should know. President cannot appoint anyone he likes. Rather, he can appoint only those persons who are enjoying majority in the Lok Sabha, and if not majority enjoyed by one single party, then the coalition of party that is enjoying majority. So the leader of that party will be appointed as the Prime Minister. But in case no single party or alliance gets a majority, in that case president has discretion, and he on his own decides whether a person should be invited to form the government or not. Now the next thing is that prime minister does not have a fixed tenure. This must be kept in mind. Prime minister is not for 5 years. The tenure of prime minister is not 5 years. Okay, he continues to remain in power till he enjoys the support of the majority in the house of people, that is Lok Sabha. After the appointment of prime minister, president appoints other ministers also on the advice of prime minister. That means president is appointing other ministers, but on the advice of prime minister. Okay, ministers usually from the party or the coalition, these things you would be knowing. Prime minister is free to choose ministers as long as they are members of parliament. If someone is not a member of parliament, then he can or she can be a minister for only 6 months. Meanwhile, he or she has to get appointed, get elected as either house of the parliament. Okay, now there are some council of ministers consists of various categories of ministers. Cabinet ministers, they are the highest ranking ministers, and they hold the important positions like defense, home ministry. So cabinet is the inner ring, the smaller part of the council of ministers, and most of the important decisions are taken by ministers. Then there are ministers of state with independent charge. They are in charge of smaller ministries which are a bit less important. Then there are ministers of state who are attached to and required to assist cabinet ministers. So the thing is that since practically council of ministers cannot meet always, that's why parliamentary democracy is often called cabinet form of government, because largely decision is taken by the cabinet. But one important aspect is that everyone has to own every decision of cabinet. This is called the concept of collective responsibility. That means everyone who is a part of the cabinet has to own the decision of cabinet. That means they have to stand by the stand of cabinet minister, even if the minister is of some other department, for example home minister, but he or she cannot criticize the policy or action taken by another minister like defense minister. That is, they are collectively responsible to the house of the people. Okay, they cannot openly criticize any action or decision of the government, even if it is about another ministry or department. This concept is called collective responsibility towards the house of the people. Okay, now powers of the prime minister. So powers of the prime minister is not very much clearly said in the constitution. The constitution only says that there shall be a council of minister headed by prime minister to aid and advise, okay, the president. And in under article 78 also a bit of duties of prime minister, that he will furnish the details of the administration, law making, etc. to the president if the president is demanding for that. So beyond that, the role of prime minister and the function of prime minister has not been given in the constitution. But since he is the head of the government, so in fact almost all the powers are invested in him or her. His decisions are final in case of disagreements between different departments. He coordinates the work of different departments. He exercises general supervision power of on different ministries. He distributes and redistributes works. Who will be appointed as a minister or dismissed as a minister? These things are taken. These decisions are taken by the prime minister. In fact, the prime minister also. When the prime minister quits, the entire ministry also quits. So this is what prime minister is about. Thus the cabinet is the most powerful institution, but within cabinet the prime minister is also is the most powerful. In fact, he is said to be the first among the equals. Anyways, you will study in polity. The powers of the prime minister in all parliamentary democracies of the world have increased so much that in recent times parliamentary democracy is now also called prime ministerial form of government. Let us take example of present government. The prime minister is enjoying so much majority and popular support. It means that he is more powerful, and that's why it is said to be prime ministerialization of the cabinet form of government. It means that the prime minister is dominating the cabinet. In fact, the cabinet is supposed to be equal. All the ministers are equal, and the prime minister is supposed to be first among the equals. But the prime minister is dominating the cabinet. This is how it is said. That's why the parliamentary democracy is also said to be prime ministerial form of democracy. In fact, in India also concentration of more and more powers in the hands of prime minister can be seen. Jawaharlal Nehru and Indira Gandhi examples have been given here. Extent of power wielded by a prime minister also depends on the personality of that person, of course. That is how. However, during coalition politics, the power of prime minister is less because he is dependent on others' support also. for the continuation of the government. That's why in coalition government there is less concentration of power. Prime Minister has to accommodate different groups and factions in the party. Now let us study something about the president. He is the head of the state. President is the head of the state. Prime Minister is the head of the government. So he is not directly elected. The president supervises the overall functioning of all the political institutions of the country. This is how it is written. The president is not elected directly. In fact, he is elected by the elected members. This word is very important. Elected members, not nominated members. Elected members of parliament and also elected members of state legislative assemblies. Okay, and this ensures that when MPs and MLAs throughout the country are taking part, elected members of parliament and elected members of legislative assemblies, this ensures that the president is representing the entire nation. Okay. Now the thing is that also when indirectly elected, then he is not enjoying the direct popular mandate as the prime minister is enjoying. Otherwise there will be a clash that both will be saying that I am the choice of the people. So to avoid these things, indirect election of president is done. The same is true of the powers of the president. If you casually read the constitution, these things are given. Okay, all government activities, in fact what is being argued is debate between article 53 and 74, perhaps 53 and 74. You should get it confirmed. 53, this makes President Julius Caesar powerful, all powerful. That means he is head of everything. He will take all the decision in the Union of India. But 74 says that he has to act on aid and advice of the Council of Ministers headed by Prime Minister. So this makes him Caesar. So Caesar to Caesar, Caesar to Caesar. This is how it is about president. Anyways, now let us come to see. All laws and major policy decisions are issued in her name. All taken major decisions are taken in the name of the president. Major appointments are made in the name of president. In fact, the president has the responsibility to appoint chief justices, various judges, high court judges, supreme court judges, then election commissioners, then governors of the state. Even all international treaties and agreements are made in the name of the president. President is the supreme commander of defense forces. So president has so many functions, but all these functions he has to exercise on the aid and advice of the prime minister, council of ministers headed by prime minister. But we should also remember that in some cases all these powers this is how this is article 74, that the president has all these powers, but the exercise of those powers depend on the advice of the Council of Ministers. So however the president can ask the Council of Ministers to reconsider the advice. So once the advice can be sent for the reconsideration, but again after reconsideration the same advice is given back to the president, he is bound to act according to it. After the president gives assent to it, the parliament, a bill passed by parliament becomes a law. If a president wants, she can delay that also. This is called veto power, some sort of this, and can be sent back also. If it is not money bill, then the bill can also be sent back to the parliament, but again if passed by the parliament and presented to the president, so he has to assent to the bill. So this is how in polity you will be reading about many things. However, it is not that president is rubber stamp. Rather, the president has at least two cases where we can see that he can act in his discretion. The first thing is that when there is no clear majority. So who to appoint as the leader of, who to invite to form the government. So this lies in the discretion of the president. Okay. Then the second thing is that under Article 78, the president can ask the Prime Minister to furnish the details of the governance system or any administration related aspects or legal things that they are going for some law making. All these things the president can ask to the Prime Minister to furnish those details. So this is how here also the president does not require any aid and advice. Anyways, the presidential system, this you will read. In presidential system, the president of the US is both the head of the state and also the head of the government. And in fact, the president does not need the support of the majority of members, as opposed to the case of India, where the prime minister has, as head of government, has to enjoy the support of majority in the House of the People. So these things you will study. Now let us come to judiciary, friends. The judiciary, the office memorandum, in that case we can see that how finally the dispute was settled by the judiciary itself. Okay, so judiciary is very important. if there was nothing like Supreme Court, so these are some questions being raised by the writer. You can read it on your own. In fact, an independent and powerful judiciary is required, and it is essential for democracy. Or now, if we say now, if we say India has an integrated judiciary, it means that there is only one Supreme Court is there to supervise all the courts in India. Then we have subordinate courts. All these things are there. So this is one only integrated. Supreme Court is supervising all the judicial functions. This is how the word integrated means. It is not that there are two layers. Like the federal system, we have one government as union and the other as state level. So this relation is not there. Rather, it is integrated. One single judiciary is there in India, from Supreme Court, High Court, and that then the subordinate courts. Okay, this is how its decisions are binding on all courts of the country. Supreme Court decision is binding on all courts of the country. It controls the judicial administration in the country of all the judicial institutions. That's why it is integrated judiciary in India. Now judiciary take up many disputes between citizens of the country, citizens and government, two or more governments, state governments, original jurisdiction. This is how between states and union. This is how it is. Highest court of appeal it is in case of civil and criminal cases, and it can hear cases against the decision of the high courts also. Independence of judiciary means that it is not under the influence of or control of legislature or executive. It is different. Judiciary is separated from executive and legislature. So it is how independence is ensured. Okay, now let us see. The judges do not act on the direction of the government or according to the wishes of the party. The judges of the now let us see. The judges of the Supreme Court and High Court are appointed by the President on the recommendation of on the advice of Council of Ministers headed by Prime Minister and in the consultation with the Chief Justice of the Supreme Court. This is how in theory, but there is collegium system now. This you should read that collegium system also. And there is very little scope for interference by the political executive. We can see in the appointment process there is less interference of the executive nowadays after the collegium system. Previously some sort of things was there. In fact, so many debates are there about the appointment of judges of Supreme Court, which we will be studying in editorial classes and discussion ED classes and also in GS paper 2. Now let us see removal of judges. They can be removed by a special majority in both the houses of the parliament and then to be signed by the president. Now one very important thing is that judiciary in India is most powerful in the world because Supreme Court and High Court have the power to interpret the Constitution of India, and within this power to interpret the Constitution it can say that see this action or policy of the government is ultra vires the Constitution, not in accordance with the Constitution, so it will be stand nullified, it will stand void. This is how it is. They can declare invalid any law of the legislature and any action of the executive that they are not in spirit of the Constitution of the country, because they are the interpreter of the Constitution. This is how we should see. In fact, they can determine the constitutional validity of any legislative action or any executive action, and when it is challenged before them, they can say it is unconstitutional or constitutional. So this is called judicial review. Okay, and the Supreme Court has also ruled that the core or basic principle of the Constitution cannot be changed by the Parliament. That is the basic structure doctrine that came from the Keswanand Bharati case. Even before that also it was there a bit. Anyways, the powers and the independence of the Indian judiciary allows it to act as the guardian of the fundamental rights also. So in democratic rights we will see that right to constitutional remedy is there, and if a violation of fundamental right is there, one can directly approach the Supreme Court. Okay, then there are several judgments and directives to protect the public interest and human rights. In fact, in some cases, if public interest is hurt, then not necessary that the aggrieved person will approach the court. In fact, some other person can also approach the court for enforcement of that resolution of that public interest related issues. This is called public interest litigation also. The courts intervene to prevent the misuse of the government's power to make decisions. All these things are there. So I think now it is more than enough. Okay friends, thank you. So we are now at chapter 6, democratic rights, democratic politics, class 9th. So we have already read about democratic elections and democratic institutions also. Now in this chapter we are going to study about democratic rights. So the first thing is life without rights. So I think you will go through the three examples given, Guantanamo Bay in US and Kosovo and Saudi Arabia examples where there is life without rights, and you will understand how rights are getting denied. And when you will understand those three examples, you will go through these three examples, you will also come to feel that security, dignity and fair play should be assured to everyone. You will also come to feel that there should be no arrest without proper reason and information. There should be a fair chance to defend themselves, for example in case of Guantanamo Bay prisoners. So these are things you will understand. Now let us see more important thing, that is what are rights. Let us first see the definition of rights, that rights are reasonable claims of persons recognized by society and sanctioned by law. Three aspects are there: reasonable claims, recognized by society and sanctioned by law. We will see these three one by one. So rights are claims of a person against fellow beings, society and government, but these claims should be equally available to others, also should be available to other persons in equal measures, and also the claim should not hurt other people. One example is given that we have right to play cricket, but it does not mean that we have the right to break others windows. That is, the claim should not hurt others, okay, and the claim should be equally possible for others. And for example, we can take this right to freedom of expression. We have the right to speak, so this should be equally available, equally possible for others also, okay. And at the same time, there is one more point that we should see: right comes with an obligation to respect other rights. Now we claim that we have the right to speak, but when someone is giving a dissenting opinion, then we stop them from speaking. So we are not respecting their right to speak. This is the thing. So when we claim a right, at the same time there is an obligation to respect others' right, okay. This is one thing. The second thing is that when we are claiming rights, it should not hurt others. The third thing is that when we are claiming rights, it should be equally possible for others also. So three things are there. When we are making claims, it should not hurt others. When we are making a claim, it should be equally possible for others. When we are making a claim, it should be reasonable. When we are making a claim, that means the right we are claiming for, it comes with an obligation to respect others' rights. So these three things are important. I hope you understood. Anyways, now the next thing is that the right claim should be recognized by society also. For example, democracy 200 years back, but there was no right to vote for women. But now in 19th century, how right to vote for women was getting recognized. This is how after this, from 19th century, we got that how the claim of the women to vote got recognition, social recognition. So this is the second point. Now see, even if rights claims are reasonable and socially recognized also, but there is need of real force. The real force, that means legal backing should also be there, because if no legal backing is there, so no one can go to the court and say that my rights have been infringed. In case of fundamental rights, for example, rights are taken away or violated, then we go to the court and the court enforces our rights. So legal backing, real force is also needed. If that is not the case, then even if rights and claims are there, they will not be enforced. For example, the Guantanamo Bay prisoners, they had the moral claim that they should not be tortured, they should not be humiliated, but they had no way to get their rights enforced. So legal backing should also be there, the real force should be there. This is how it is. All those things, that when rights are infringed, violated, then we can approach the courts to protect the rights. So this is how the definition of rights. So I hope you understood. Now let us see why we need rights in a democracy. So 3 points are there. The first is that in a democracy we need to vote and to choose our representative, and for that we need to have a discussion among ourselves, the freedom of expression to build our opinion, that whether those people are good for voted into the power or not. That means right to freedom of expression is needed. Then only we can discuss among ourselves, we can criticize the government policy, all these things can be done, and then only we can truly elect a right candidate. So this is the first thing. The second is that rights protect the minorities also, because in a democracy there is generally rule of the majority, and rule of the majority is there. Minorities, then the minorities are at risk. How their rights will be protected. In fact, they are fearful of getting oppressed. but their operation is stopped by ensuring these rights. For example, fundamental rights in Indian Constitution, they ensures various rights for the minorities also, and that cannot be taken away by majority people. So this is how rights have importance, that they protect minorities from the expression of operation of majority. Then the third thing is that many a times the government may themselves attack on the rights of the citizens. For example, suspension of internet services, so freedom of expression is getting affected. But although it may be in the name of national security, that is different debate. But the thing is that many a times government themselves impose unreasonable restrictions and take away the rights. So in that case, what to be done? Therefore fundamental rights are there in a democracy. In our democracy, fundamental rights are there, which cannot be taken away or abridged by the government, and if they are abridged or violated, then one can go to the court directly, Supreme Court directly, under Article 32. So these three things are very important. First is that freedom of expression is needed to criticize the government policy and form public opinion whether to vote in or vote out that government. Second thing is that rights ensure that there is no oppression of the minorities by the majority. The third thing is that governments do not take away certain basic minimum rights from the citizens. Okay, so this is how in a democracy rights are important. Now let us see, friends, the rights in the Indian Constitution. So there is a fundamental right, part 3 of the Constitution, and in fact the preamble of the Constitution also says about equality, liberty and justice. This is how our goal is. Anyways, let us see the fundamental rights. See, many things are given in these rights, and I cannot read line by line. That's why I will give you the essence of those rights. Okay, and you will on your own read every line, and then you will discuss with me if any confusion is there. So first is the right to equality. Under Article 14 it is there. 14 to 18 we have right to equality. 14 has two aspects. One is the equality before the law, and other is the equal protection of the law. Equality before the law and equal protection of the law. If we speak about equality before the law, it means that should be rule of law. That means law is above everybody, whether president or prime minister or anybody. Law is always above. It is not the case of authoritarian rule that king is everything. No, in this case law is everything. So there should be rule of law, and in fact this rule of law is the foundation of any democracy. In a democracy, no person is above law. So law should be there to rule. So this is equality before the law. Then we have the concept of equal protection of law. Equal protection of law means that, see, very attentively you should see, equal protection of the law means unequals should be treated unequally. So if Mr. A is earning 10 lakh per month and Mr. B is BPL, hand to mouth, then for B free ration, free water can be provided, and for A there can be tax or user charges for water. But the thing is that one will say there is no equality in case. But see, this is because both are unequal, so they should be treated unequally. This 10 lakh per month person can bear the cost of water charges or ration, but this BPL person cannot bear that charge, so he should be or she should be given free. So this is what equal protection of law is about. It means that unequals should be treated unequally. So this is how we have, and this very good example of one prime minister, how he was going to court and producing evidence. So this shows the rule of law, that even prime minister is below law. Okay. Then these things that in this paragraph we are going to study, this is in fact Article 15 that prohibits discrimination, that there should be no discrimination. For example, there should be no discrimination against any citizen on the grounds of religion, race, caste, sex, place of birth. Then there should be no discrimination against person that no, you cannot access to the shop, cinema hall. In fact, this is against untouchability. Similarly, there are many things. You will study these things on your own. This is not too much difficult. Then there is also Article 16 also that says there should be no discrimination in case of public jobs also. Article 16, this is from part 3. All citizens have equality of opportunity in matters relating to employment. This should be ensured by Article 16. Now one debate is here, that is reservation against reservation. Is it against the right to equality? Then we must tell that equality is of two types. One is the formal equality and the other is substantive equality. Formal equality is that equality of opportunity, anyone can apply, 21 to 32 years, whether scheduled caste, scheduled tribe, any person from Delhi, from rural area, any person can apply. This is formal equality, that is equality of opportunity is given to all. But see, there is no substantive equality, meaning that a person who has access to good quality of education, has read in very high quality schools and colleges, and there is another person who has read in the village schools. So how there can be equality of opportunity? So in true sense there cannot be equality of opportunity. That's why those person SC, ST and OBC person are required to even compete at lower marks. So this is how the substantive equality is ensured. Equality of opportunity should be substantive also. Okay, this example, I hope you understood my point, that substantive equality should be there. A person who has read in so high school and a person from village school, how both can compete in the same UPSC examination? This you should keep in mind. Okay, that is unequals should be treated unequally. So equal protection of the law that we discussed above also justifies this reservation policy. Okay, uh, constitution says that reservation of this kind are not a violation of right to equality. You should see all these things also. Then this principle of non-discrimination extends to social life also. In fact, there is Article 17 which prohibits untouchability and also makes untouchability a punishable offence. In fact, this was one historical problems with in our society, and this should be of course removed. Then comes the right to freedom. This right to freedom from Article 19 to 22. Freedom of Article 19 one has Article 19 has so many rights: freedom of speech expression, freedom to assemble, freedom to form association, unions, freedom to move throughout the territory of India, reside in any part of the country, to have any profession, occupation. These are freedom. Okay, but see, these freedoms cannot be unreasonable. Okay, see, they accordingly the government can impose certain reasonable restrictions also on these freedoms. These freedoms are not absolute. This freedom is not unlimited license to do what one wants. In fact, this freedom can be curtailed also in certain circumstances. For example, in case of defamation, right to freedom of expression does not mean you can defame any person. Okay, this is how it is. Now let us take example of freedom of speech and expression. It is one of the essential features of any democracy. Freedom of expression is needed. We saw how democratic rights are important in a democracy. So freedom of expression is needed. That's why we will be freely available to able to communicate with the people. In fact, when we disagree with a policy of the government or its activities, this right to freedom of expression helps us to criticize them. Now see, freedom of expression does not mean only uttering a word. It means even using a pamphlet, magazine, newspaper, writing an article in newspaper, or making cartoons, giving writing poetry, songs. So through various gestures this freedom of expression can be there. But of course one cannot instigate violence against others, and also one cannot incite people to rebel against government. So these are some reasonable restrictions. Okay, defame others, this example I already gave you. Citizens have the freedom to hold meetings also, processions also, rallies and demonstrations all on any issues. We can see how these things are done in our everyday life many times. For example, IAC, yes, India Against Corruption. We can see how it came together. Some people came together to exchange idea and mobilize public support in favor of Jan Lokpal bill. Okay, but such meetings should be peaceful. It is very important, and without arms it should be. Then workers also can have their unions. This is how this right is. Then freedom to travel to any part of the country is there. For example, when people migrate from villages to towns in the search of some job, then they are in fact utilizing this fundamental right of freedom to travel to any part of the country. Okay. Similarly, women cannot told that some kind of occupations are not available for them, because we saw above that 19.1 says that there is freedom of avocation, that is freedom of trade, business, all those things. Now there is one more fundamental right, that is life and personal liberty. Article 21, that no person shall be deprived of his life and personal liberty except according to procedure established by law. This is how it is. Although Article 21 is a very big thing to tell, but here we will only confine ourselves that no person can be killed unless court has ordered a death sentence. Okay, no one can be killed without judicial approval of the judiciary. Then there are certain other conditions also, that a person who is arrested should be and detained should be informed of the reasons why detained, then should be produced before the nearest magistrate within 24 hours, then right to engage a lawyer. See and contrast these things with the prisoners of Guantanamo Bay. You will understand how these rights are being taken away from those people. Now let us come to this right against exploitation. Right against exploitation, in this case there are Article 23 and 24. So Article 23, it says that the Constitution prohibits three specific evils First is the trafficking in human beings, largely of women, for immoral purposes. Then our constitution also prohibits forced labor or begar. This is also prohibited. This is fundamental right, that no people can be forced for begar, that means render service without any charge. Similarly, constitution also prohibits child labor, but see, this child labor has been prohibited for only those below the age of 14 years, and to work in also from only working in hazardous works. So constitution says that children below 14 cannot be employed in a factory, mine or any hazardous work. It means in non-hazardous work they can be employed. Anyways, it is a point for you to think over. Anyways, so in bidi making, in firecrackers, all these things, these children are not employed. Now there is right to freedom of religion also. So this is also very important, because India is a secular country, and we have seen in the preamble also. Secularism means that India will be making an equal distance from all religion. Hajj subsidy was there, then government prepares and makes arrangements for various Kumbh Mela and all the religious events. But the thing is that the government will not support or favor or give privilege to any religion. Rather, the government will maintain equal distance from all religions. In fact, the secularism in India is not neutral. It is not about government being neutral or away from the religion. In fact, in case of public health, morality, decency, on these grounds, even government can interfere in religious matters. Okay, Sabrimala temple case, we can see. Anyways, the thing is that but no religion will become the state religion, and no religion will become the favorite for the state. Okay. Then the second thing, right to freedom of religion, we can see is right to profess, practice and propagate the religion. Profess means to say that yes, I believe in Hinduism or Buddhism or Jainism or Islam. Then practice, that means the right to practice the rites or rituals, many things we do. Then propagate the religion also, we can say that yes, my religion is good because of this thing, that thing. But this does not mean that a person has right to compel another person to convert into his or her religion by means of force, fraud, inducement or allurement. That means forced conversion is not allowed. Although one may propagate one's religion, but cannot force others to adopt their religion. This is how it is. One more aspect is that you will read all these things, friends. I hope you must read these things on your own. One more thing is that the government cannot compel any person to pay tax, and that tax will be used for the promotion of other religion. In fact, this is article perhaps 27, and in essence this ensures there is secularism. That is, the government is not taking tax from Mr. A and then means from any person and using that tax for the promotion of another religion. So this cannot be done. So this is also one essence of the secularism in India. Then comes the cultural and educational rights. So see, this is article 29 and 30. In fact, constitution guarantees rights of the minorities, and in fact minorities rights should be guaranteed, because in a democracy there is rule of the majority, and that's why operation of minority can be there. So their rights must be ensured, and this is what we saw in the above discussion at the beginning of this chapter. So now let us see what the government is providing. Government is saying that any section of citizen with a distinct language or culture have a right to conserve it. Any section of the citizen. So it is not about minorities only. Mind it. It is about any section of society having a distinct language or culture. They can have a right to conserve it. Secondly, it is said that the admission to any educational institution maintained by the government cannot be denied admission in those institutions on the ground of religion or language. That this person is from minority, so it cannot be admitted into this institution. So this cannot be done. All minorities have also rights to establish their own educational institution of their choice and run and administer that. So this is how minority have various rights given. But minority is not about national level only. Okay, this you should also see. Now the thing is that how we can secure these rights. Now comes the right to constitutional remedies. In fact, all these rights that we discussed are there in part 3, given, written. But how to enforce them? If those rights are not enforced, it means that they are merely in paper, they are of no use. So to make them enforceable, there is another fundamental right itself, that is right to constitutional remedy, that if any of those rights are infringed upon, the person can directly go to the Supreme Court and also High Court, and those courts will order for the enforcement of their rights. This is how it is. This is why Dr. Ambedkar said that constitutional remedies. Right to constitutional remedies is the heart and soul of the constitution. Fundamental rights are guaranteed against the actions of the legislature, against the action of the state. The meaning of state has been defined under Article 12, and you will see the fundamental rights are guaranteed against the action of legislature, executive, and other authorities and agency of the government. There can be no law or action that can violate the fundamental rights. Article 13 says this, that no law can be made by or order or any notice or some definition is there about law. There can be no law which can take away or abridge the fundamental right given in part 3. That's why fundamental right is very important. Even the government cannot take away those fundamental rights so easily. They have to amend the constitution, and that too subject to the basic structure. However, we should not go into that details. Supreme Court and High Courts have power to issue direction, orders and writs for the enforcement of the fundamental rights. There are 5 types of writs, and you must be knowing this. If you don't know, you should study. Yes, here this National Human Rights Commission, you must study these things, because many times small things are there. The NHRC can summon witnesses. Now a statement is given in prelims that NHRC cannot summon witnesses, so the statement will be wrong. So this is how you should study at least once or twice this given NHRC, National Human Rights Commission. Okay, see, there is one more concept, that is public interest litigation. In fact, generally the thing is that whenever there is one person aggrieved, then that person himself or herself goes to the court. But in case of public interest litigation, locus standi principle is not there. That is, the aggrieved need not go to the court. Some other person in the behalf of that aggrieved person can go to the court, that there is public interest involved, and there should be enforcement of the rights of those citizens or group of citizens. This is what PIL is, public interest litigation. In case of any violation, aggrieved persons can go to the court, but any person can go to the court against the violation of the fundamental right. That means not necessarily the aggrieved person. It is of the social and public interest, so it will be called PIL, public interest litigation. Okay. Now expanding a scope of rights. So the first thing is that the rights which are given in fundamental rights part 3, they are not the only rights. In fact, rights are much beyond that also. One good example is right to information. In fact, this right to information was once declared by Supreme Court to be a fundamental right under Article 19. Under Article 19(1). That is, there should be right to information. That is, we have the right to freedom of expression. Now we have to express that we are in agreement or disagreement with the government policy, but we are not having information about the policy. Then how we will be utilizing that, exercising that right to freedom of expression? So right to information is hidden in that right to freedom of expression. This is what Supreme Court said. And at a later stage, this fundamental right, this right to freedom of right to information was given a statutory backing through RTI Act. This we know. So there is expansion of rights. This is how it is being argued here, that beyond fundamental rights given in part 3, there are now more and more rights. For example, right to privacy under Swami case recently, it was in news, that was inferred from to come from Article 21. This is how it is. Then the second thing is that there are also many rights which are flowing from international covenants. For example, international covenants on civil and political rights, international covenant on protection of child rights. So these are also ensuring rights at the international level. Okay. Then the third thing is that now some newer constitutions, for example of South Africa, 1990s, it was built, it was framed. Then they introduced right to privacy also in the constitution, right to environment also, right to access to adequate housing also. These rights are not directly mentioned in the constitution or in the fundamental rights, but now this constitution of South Africa has mentioned this. See, one thing in GS paper 2, there is one thing, one syllabus, that comparison of different constitutions. So this is one potential question at any point of time, that Indian constitution and South African constitution may be compared, because in NCERT this is given. Okay, so from that syllabus for GS2, that comparison of different constitutions of the world. So you must know, you must read these things. Okay, this is how this chapter ends. Thank you, friends.